We have breaking news. The judge in the United Healthcare CEO murder case says the suspect will try a psychiatric defense. At today's hearing, the judge agreed to dismiss a criminal count related to possession of a large-capacity magazine. The judge had already ruled the magazine can't be used as evidence because of an improper search. But now the judge says the suspect's attorneys will try to show he was suffering from extreme emotional disturbance. ABC legal analyst Brian Buckmeyer is here for more on that. So, Brian, what does this mean for the trial?
I think before we even get there, the big thing is that this defense kind of gives us an understanding as to why the previous appearances were so secretive. There must have been some sort of arguments about HIPAA. But to answer your question directly, what it means for the defense is, and as the judge has said, the defense has to turn over all psychiatric information to the prosecution. They're going to have the ability to rebut that he had an extreme emotional disturbance at this time. It could, in a worst-case scenario, delay the trial because the prosecution will say, hey, we need our own expert to evaluate this defense and see whether or not we can make arguments against it. If it doesn't delay the trial, it's going to add a whole other argument here that's going to be at the time in which Mangione committed the crime. This is what the defense is going to argue. He had an extreme emotional disturbance. He acted upon that extreme emotional disturbance, and it was objective considering who he is in the circumstances that he was. And if that happens, it actually reduces the penalties that Mangione faces. He could still possibly go to jail or prison, but that's how it changes his case.
So you add an option for reasonable doubt by saying even if you think he did this, you can think he did this for this reason?
Yes and no. Think of it almost like self-defense, right? With self-defense, you're not saying the person didn't punch the person. You're saying, no. The person did punch the person, but here's a legal reason as to why the charges should be different. With extreme emotional disturbance when it comes to a homicide, you're saying, no, he did hurt this person. He did kill this person, but at the time he did it, his mental state was different than a person who is like you or I, right? Mm-hmm. And because of that, it's not murder, it's manslaughter. And for Luigi Mangione, that's a difference of life in prison without the possibility of parole, down to what's called a B felony in the state of New York with a minimum of 5 years to 25. So you're greatly reducing his prison sentence if you win that argument.
So how does this change the strategy for the prosecution?
For the prosecution, they're going to say, we still have to do our job. We still have to prove that he planned this, he did this. And I think the planning is what's really going to be a bigger part of this case now, because they're going to say, you can't have extreme emotional disturbance if you plan this out in a different part of the state. You traveled all the way to New York City. You have all these writings in your books. You have all of this planning and preparation. You're not extremely emotionally disturbed. You knew what you're doing. Now, was this a disturbing thing to do? That you have an issue with the healthcare system and then you decide to go kill someone? Yes, but it doesn't fit the legal description. There's going to be another robust argument here, or they'll just simply attack his psychiatric evaluation and say, this is kind of made up. This seems, as I spoke to an expert before I got on here, this seems like a cop-out.
What happens if he is found guilty by reason of extreme emotional disturbance versus guilty of murder?
Yeah, so the way we learn EED in law school, the perfect example is a spouse comes into the bedroom, sees their spouse cheating on them, and kills them. It's not murder, it becomes manslaughter, right? So from a sentencing standpoint, in New York, murder, 25 years to life, manslaughter, 5 to 25 years. So you beat the murder, and now you're talking manslaughter. And so you're looking at a better range from the defense of prison, and you're also looking at a different argument. You're not saying this person is insane. You're not saying they don't understand what they're doing or what's going on.
So it's not the same as an insanity defense.
No, these are two very different defenses. Insanity defense is like saying you're able to sing the lyrics of a song, but you don't understand or appreciate what that song means. The joke that I use in jury selection is, I'm born in '88. When Genuine came out with Pony, I was like 8 or 9. I could sing the song. I did not understand what it meant. Extreme emotional disturbance is saying you understand what's going on, but you had an extreme emotional disturbance that you could not conform your actions to what you were doing.
All right, Brian Buckmeyer, we're going to unpack this a lot more. We appreciate the analysis as always. Thank you.
My pleasure.